Good afternoon, everybody. Thank you for taking time out to join us this afternoon for our retail monthly health check with Retail Leasing. I am joined today, as always, by Mr. Kyle Swain, the retail director of LPC Cressa. And given how retail leasing has been in the headlines for just the last month, we have some very interesting topics to talk about this afternoon that you will all definitely find relevant. So, Kyle, why don't you share with our attendees what you're going to talk about today?
Yeah, thanks, Jess. I'll get straight into it because there is a lot to cover. If you could just go to the next slide, I'll talk to that and just introduce today. So today there'll be plenty for people who are still negotiating or renegotiating, depending whether you've been re-impacted, like our Melbourne retailers and elsewhere, or if you are still trying to get agreement on your initial rental assistance package from your landlord. So it'll be very beneficial for all those people, but there will also hopefully be time at the end for me to cover off a couple of other key things, which will perhaps be beneficial for everyone. And as always, some time at the end for specific questions from people who are online today. If you have anything that you would like our view on, please, during the course of the next 15 or 20 minutes, type your question in. There has certainly been plenty happen over the last month since the last webinar. Just when we thought things were almost easing off and regulating a little bit, the whole thing's exploded. So Melbourne continues in lockdown, obviously, and dealing with that. Very difficult situation for a lot of retailers down there and others. As Jess mentioned, we've seen an enormous amount of retail news in the last few days and escalating tensions between some of the larger retail brands or companies and our landlords. So I wanted to start today just by sharing this with you. This is my own view and something we talk about with landlords regularly, is that in sharing the burden, which was the intent of the code and was very much featured early on in the communications from Scott Morrison, good faith negotiations between landlords and retail tenants require neither party is looking for a win-lose or even a win-win outcome, which is often talked about in negotiation terms. However, the unprecedented circumstances the pandemic has created requires that both parties look simply for the least worst outcome and understand there are no winners from the National Mandatory Code. Everybody is going to lose out on this. The best you can hope for is an acceptable degree of loss and an opportunity to recover over the next lease cycle, which is the whole concept of continuity that the whole code is based on. And in order to do that, there must be continuity of business. The retail store must be able to continue to trade, and the landlord must also be able to provide a premises from which the store trades. So there's no benefit to anyone if one or both parties don't survive this pandemic period and aren't in business to go through the recovery period and out the other side. So I just wanted to get that term across, least worst outcome, rather than looking for a win-win. If you go into negotiations, I think with that concept in your mind, understanding that both parties are impacted and both parties are losing money in this situation, then it's easier to have a sharing the burden approach to the negotiations. So we'll go to today's focus, Jess, on the next slide. And I'm going to talk through the 5 stages of negotiating rental assistance under the code. And this is the topic virtually came from my meeting this week with the Small Business Commissioner here in Queensland. Marie Adsheed, the Small Business Commissioner, their office most definitely takes this approach and to situations they're dealing with. So I have borrowed that for today, and it's quite handy to go through each of these stages. And what I want to refer to is the two key areas where these negotiations are stumbling or getting stuck, and where most of the cases that end up in mediation or seeking support from the Small Business Commissioner's office fall into two of these particular sections. So I'll jump straight into those and just cover them off very quickly. Of course, this webinar is being recorded, so you can come back to it and access these notes, but I'll go through quite quickly to leave some time at the end for some other stuff. Number one, ask your landlord to negotiate rental assistance. That's the first step. That request should be in writing, and in that request you should be confirming a number of things with the landlord initially. So to confirm that you're eligible for relief, the relief that you're asking for. Your lease, you need to have an eligible lease under the terminology through JobKeeper and in the code. An eligible lease is an entity that turns over less than 50 million. The small medium enterprise, confirming lease is an SME under 50 million. Confirm the entity qualifies for and participates in the JobKeeper scheme. We've talked through all of this before, but these are just bullet points that you need to confirm with your landlord. Advise them of the impact of COVID-19 on turnover. In the past, we've provided a simple spreadsheet that you can provide, which is signed off and provides a very clear view of the impact in relation to turnover. Be clear with them about what you're requesting. Proportional relief, or for some situations it might be something different to that, and ask for a response from the landlord with their return offer. If we just go on to the next one, where number two is to share, and what we're sharing is accurate and sufficient information, which is the terminology again in the code. And this stage is the first sticking point. A lot of the mediations going to the Small Business Commissioners is in this stage. As you know, or many of you may have experienced, once you request some relief, the landlord asks for a lot of information. Hopefully, the information you've provided in stage one that we've just talked about removes this roadblock, but we have talked a number of times about landlords being quite onerous in what they're requesting. The keys to successfully moving through this stage is to act in good faith, provide evidence of eligibility under the code, which we just talked about, provide accurate turnover figures to allow the landlord to assess the direct impact of the pandemic, be transparent with the landlord. There are a lot of mediations occurring mostly because there's a lack of trust, because one or the other party won't provide information or certain details, and obviously the other party is going to feel that something's being hidden or they're not acting in good faith. If asking for more than the minimum obligations, be prepared to share more. So strictly under the code, it should be ample to provide turnover rents only. If you're asking for waived rent only and no deferred because of the financial implications of that on your business, or you're asking for additional relief over and above the percent of impact purely on turnover, then you do need to be prepared to provide some more detailed financial reporting, like P&Ls, and that show your net profit, your cost structures and so on, for the landlord to assess those those requests above and beyond the minimums of the code. But still reject onerous requests for information. And so these last two I've highlighted with a little blue asterisk, because these are typically the points that are ending up in mediation or ending up as disputes where there's not agreement between the two parties. Onerous requests, things like future forecasts and cash forecasts for the next 6 months, and some of these types of things. Most states, small business commissioners list these, what they consider onerous, on their websites if you are having that issue. I'll also note here that in dealing with these roadblocks, the Small Business Commissioner's Office doesn't automatically go straight into a mediation process. If you do need to contact them, they're prepared to just contact your landlord and see if explaining some of these things to the landlord removes that roadblock for you before it needs to be lodged as an actual dispute and go through mediation. So they can be extremely helpful where you do experience these roadblocks. A number of the states have in the regulations or the Act an allowed time frame for the landlord to respond with an offer, 14 days or 30 days. In Queensland it's 30 days, in WA it's 14 days, for example. Just note that time frame commences, in Queensland case particularly, not when you ask for the assistance, but when you've provided or shared all of the information requested, as long as it's not onerous. The next one, number 3, is about the offer, and this is where the landlord should respond with an offer. The offer may be simply agreeing to what you've asked for, or it may be a counter offer of a variation of that, or a higher percent of deferred rent rather than waived than you asked for. But that's the landlord's offer. It can also include some other lease conditions where they may waive certain things. They may want to provide you with a good assistance package on the condition that you extend the lease term or something like that. This is where that will all be stipulated. And it's worth noting that most landlords and tenants, the methodology applied to assessing the impact and the interpretations of how to do that vary fairly significantly. But again, it's a negotiation between two parties. So if you're okay with how they've interpreted, great. If you're not, then it becomes the next stage, which is negotiation. So it's important to remember that the offer should not be a final position. There's been cases turn up at the Small Business Commissioner's Office as a dispute, which based on the landlord's offer not being what the tenant wanted, but they haven't actually negotiated beyond that stage. So where you should go from here is to stage 4, which is to negotiate a mutually agreeable outcome. Going back to where we started, this is more likely to be a least worst position for both parties rather than a win-win for both parties. And it's not likely to be what you requested or what they suggested. Hopefully it's somewhere in between. but something that both parties can agree on. You'll note that this is the second sticking point. So stage 4, if you've worked your way through the rest, is this stage is ending up at the Small Business Commissioners, the mediation process. Mediators are interacting between both parties to try to achieve outcomes that are mutually agreeable, when the landlord and tenant both have quite different views on what may be reasonable. The keys to this stage are to remember that you need to cooperate with each other to achieve an agreeable outcome. Act reasonably, act in good faith, and for retail tenants, you also need to be mindful of the landlord's financial circumstances. Not every retailer is in a super regional shopping centre under a Westfields or a Vicinity or someone else. Many of you are, your landlords may be a small self-managed super fund, a mum and dad who rely on the rental income for their living, and those sorts of circumstances need to be taken into consideration. That also deals with the aspect where you may actually have discussions around what benefits the landlord has received around land tax and things like that to reduce your outgoings component. And then hopefully we work through all of that, achieve a mutually agreeable position, and the last stage is to document the agreement. This is also being done in numerous ways, from a variation to the lease, particularly where there's an extension of the lease involved, or as simple as a 1 to 2 page letter that the parties sign. But what's important to put into that agreement is that there's a start and end date to the period of this assistance. What proportion of that assistance is waived and what proportion is deferred, how the deferred component is to be repaid over what period and commencing when, and dealing with any other changes to the lease conditions. As I said, if the lease is extended or if you've agreed to some other benefit or to give up some component of your lease, that needs to be documented. There needs to be a clause in there dealing with whether one party or the other actually breaches the terms of that lease and that doesn't meet the terms of it. Unfortunately, we need to cover that off and have a pathway to follow that up. And then regulations or the retail legislation are not contracted out. So there's a number of agreements being offered to tenants which prevent them from future claims, and other things might be included in there that is normally a provision under normal retail legislation or particularly under the COVID regulations, which some of these agreements are removing by saying that you are not able to access something or not able to renegotiate or negotiate any further. The most common one, you're not able to negotiate any further rent relief or assistance if certain things happen. So that's called contracting out, and we want to make sure that those sorts of clauses aren't prohibiting your future rights, particularly considering that this is nowhere near over. And I may just move to that in the next section. Well, firstly, what if you do get stuck? it says here to seek assistance. So revisit these 5 steps and the points within them and try to identify where the roadblock is. If you can identify that and improve that situation, maybe go back and revisit that and provide a little more information, or readdress something that is causing that roadblock, then you may be able to move past it, which would be great. Obviously, the NRA is a great source for you to seek some advice. Those inquiries do come through to LPC Cressa, and myself or one of the other advisors will personally respond to that and assist you with advice on the best way to deal with that situation, or what your rights are, what your obligations are, and so on. The Small Business Commissioner in your state, they are a neutral party in this. They don't take sides, and they can provide assistance, as I mentioned before, by calling the tenant or calling the landlord and trying to provide some explanations which may help to move past roadblocks. And there's always the option of progressing that to a mediation to achieve an outcome. And then, of course, other specialist tenant representation if required. Certainly, if you send your inquiry through to the NRA in the first instance, LPC Cressa, as the leasing advisor of the NRA, can assist, and we certainly do get engaged by many of the association's members to act on their behalf in negotiations, whether it's COVID-19 or other lease events that they're dealing with. Hopefully some of you have agreements in place, and all that was just recapping and fresh in mind if something drastic happens, like happened to Melbourne, and you need to revisit negotiations. You can revert to that and follow that process again. But for everyone, what happens after September 30? Apart from New South Wales, which started a little later, every other state's regulations or acts, the bills that give effect to the code, expire on September 30. New South Wales is October 24, and after that date, the mandatory code of conduct is actually not a legislated code anymore. The real fear is that there are many landlords who will, on October 1, begin those actions which are prohibited during the pandemic period up until September 30. The prohibited actions like issuing default notices, terminating leases, and accessing your bank guarantees to repay outstanding amounts and things like that. So clearly that is a huge concern to every state, to the NRA and the other associations. And it's being discussed and dealt with, unfortunately, on a state-by-state level. New South Wales and Queensland at this stage, we're very unsure as to what will happen. Victoria came out with initial extensions to certain provisions from the Act down there, which protects for an extended period of time tenants against those prohibited actions particularly. We believe now Victoria's announced that they will extend a regulation around the code. I expect South Australia will announce doing exactly the same, and I think in the next week you'll hear announcements about New South Wales and Queensland. It's more likely expected to be a lighter version of the existing code rather than an extension of the regulation currently in effect. Just like JobKeeper evolved and changed, and the number of people and the amount of money and things like that are different in the extension. I think you'll see provisions in there to protect tenants to a degree and to extend support to a degree, but not a straight extension of the existing legislation. Stay tuned. And that will all be coming out. And I think in our next webinar, we're, unless something else happens, we may just cover off that next period, the extension period, or in the absence of extension of the code, how to deal with the ongoing issues caused by the pandemic.
Alrighty, so more on that to come. So
Yes.
We have some questions now, and they're actually rolling in because there's so much good information to come out of this webinar. So we'll start out with Charles, who asks, "Hi Kyle, thanks for the informative webinar. In Victoria, it has been announced that the code has been extended until the 31st of December. There are some other changes to the code in Victoria to bring it in line with other states proportionally. What would you recommend Victorian retailers do to renegotiate the best outcome for themselves, and when that would apply? For example, can it be backdated? Secondly, do we expect to see other states extend the code of conduct in line with Victoria and JobKeeper? Thank you."
Hopefully I've just covered off that second part with the other states. Victoria has extended their code to a degree and until December initially. Hopefully the other states extend it right through to the end of the second JobKeeper period to March. But as I said, those announcements will come out. I believe South Australia will be next cab off the rank to do that. And hopefully Queensland and New South Wales over the next 10 days, hopefully, will do the same. In terms of those Victoria initially who have that code extended, my recommendation to anybody who is still impacted now would be to assess the situation, whether the lockdown comes off or not, what their current agreement is, and just revisit these 5 stages that we've talked through today. I've no doubt that initial agreements are able to be renegotiated. Most states, the current legislation does allow, specifically state that agreements can be revisited, and we've covered that off in a previous webinar on how to revisit, amend or extend existing agreements. So it'll be a matter of each state and what they exactly which parts of the regulation they extend. But
Right.
revisit these 5 steps and start from point 1. If there's already an agreement in place, start from what that agreement is and ask for assistance to be extended on the same terms or on whatever new terms your business needs based on the impact.
Yes, very good advice. And also from Charles, "Hi Kyle, if a tenant has signed an agreement which it states this is effectively a final settlement, is there anything that they can do to revisit their agreement, especially if the code of conduct was not followed properly in the agreement, for example, not in the whole 6-month period? Thank you."
Yeah, as I said, a number of states specifically deal with that in the legislation. That if anybody entered into an agreement, for example, prior to the legislation coming out, they feel that they're disadvantaged because of that, then they're able to renegotiate those terms. We had examples, say in Western Australia, had a client who was being pressured to sign an agreement in very early April. Had they signed that agreement and then the legislation came out over there, which was much more friendly to them than some of the other states, their agreement that they were able to negotiate under the regulation over there was a better agreement. But for the ones who may have signed that agreement with the landlord prior to that coming out, the legislation allowed them to renegotiate in that situation. There's other states' legislation says similar thing. Not every state. New South Wales doesn't overtly state that, but if the landlord's not willing to renegotiate on that basis, I would be addressing that situation through the Small Business Commissioner.
Okay, thank you for that, Kyle. And one more question from Mark. Despite the freeze on rent increases under the code, some landlords are increasing things like marketing or promo levy. As this is typically linked to base rent, which cannot be increased under the code, should increases in these marketing and promo levies be rejected by tenants?
Yeah, I'd say absolutely, Mark. I think the intent was for no increases in costs, and the various regulations brought in cover that as well, and even state that those types of costs should be reduced wherever possible. So if you're in a centre and there's limited foot traffic, let's say a shopping centre in Melbourne right now, and there's very limited foot traffic, they shouldn't be conducting the marketing and incurring those costs, and those savings should be handed on to tenants, not the other way around. So I would certainly have an issue with that, and I would push back against that and take it further if necessary.
Yes, that sounds very good. Okay, thank you for that. That is all the questions we have for now. Kyle, are there any last notes that you would like to add?
Yeah, look, there's a lot going on in the news. I'm sure everybody's seen the dealings between the larger shopping centre landlords and the larger retail tenants. It's very interesting stuff going on right now, but I would encourage everybody to stay focused on your exact situation and work through those 5 stages of your negotiations. Continue to act in good faith and be quite transparent with your partner. If you remember, very early on in the process, we did a webinar about the importance of thinking of your landlord as your one of your key stakeholders, one of your retail partners. And I think that that is truer now than even when we presented that. Please have conversations with your landlord with respect and a recognition that some of the landlords are also losing very large amounts of money. Westfield reported losses of $3.6 billion. And you've got to respect that many of these landlords are significantly dipping into their own pockets and to provide some relief to their retail tenants. Hopefully you can work through everything in good faith and cooperatively to achieve the best worst option for both of you.
Yes, that's certainly something we all need to do, is proceed in good faith. So that's all the time we have for today. Thank you, everybody, for joining us this afternoon. We hope that you found this webinar particularly insightful, as some of you are most likely in negotiations right now. If you have any in-depth questions that you need assistance with, please forward them to marketing@nra.net.au, and they will be passed on to Kyle and his team, who will help you on from there. And we hope to see you again soon. As always, Kyle, it was a pleasure. Thank you for leading us today.
Thanks, Jess. Thanks, everyone, for being here.